Good morning, Mr. Upchurch. How are you?
Morning. I'm all right.
Yes, I'm Parole Officer Truscello, and we're here for your preliminary hearing. However, I have Attorney Jones with me from the Public Defender's Office, and she just wants to speak with you quickly about her representation, okay?
All right.
All right.
Okay, so good morning, Mr. Upchurch. It's my understanding that you want the Public Defender's Office to represent you. Is that accurate?
Yes.
Okay, so just so you know, obviously we didn't contact you. We were unable to reach you to take your public defender application. So if you want representation from our office, we need to take an application from you. So our request would be for a continuance today so that we can take your application and represent you. Is that what you want, or do you want to represent yourself?
No, I can represent myself. I'm saying everybody. I don't feel. Oh, wait. Just give me a second. Let me just think what I'm gonna do.
Yeah, think about it. It's important. No, take a second because it's important, Mr. Upchurch.
Do you have what the possible next date would be if it was?
I could put him on for my next hearing, the 5th. The 5th, a week from tomorrow.
Okay, so if you had a continuance, just so you're aware, the next date that's available is November 5th, which is next week. So it's not like it would be a month or 2 months. It would be a week. And that way you would have representation and someone would talk to you about your case.
Okay, so what I'm saying is, cause I just had I filled out the application when I was in Hartford County, but y'all probably didn't get it. But that was like revocation application though. I don't know if that's the same thing.
Well, you filled out a public defender application?
No, I filled out. Yeah, it was like it said they sent me parole revocation. They said if you want to be represented, fill this out. Cause I just did it like a couple months ago, so I know what it looked like. It was they said contact. They gave me the number 5964370, whatever, and I don't know. I said PRU though.
Right, so we would have sent you an application, but it wouldn't have been months ago because you were just remanded.
No. I didn't say months ago. I said I just sent it. I said I did it months ago before when I was just in Hartford County, miss.
So you're saying on a previous violation you did it?
A previous technical, yeah, I just did it. But what I'm saying.
Yeah, so every time we would represent you, this would be a new representation. We would need to take another application from you. We can't go back and use an old one.
No, I know. What I'm saying is they gave me one in Hartford County just like a week ago. That's what I'm telling you.
Okay.
I just got transferred over here a couple days ago.
Okay, so did you mail that application back to our office?
I mailed it back. That's what I'm telling you.
Okay, so then we didn't receive it back yet. So it's probably going to come back any day now. But in any event, somebody still needs to talk to you about your charges, go over your defenses with you, so that you can be prepared. What's that?
So you can't talk to me about that?
Not right here on a live hearing. That's not proper representation. That would be a private conversation between you and your attorney to go over your possible defenses.
And like Attorney Jones said, my next hearing is a week from tomorrow, so it's not super long way out if you do choose to wait. It's next Tuesday.
Oh, that's the 5th.
That's the 5th, yeah. But yeah,
So, I got you a question.
Yes.
I'm just kind of a little confused. I'm just like, I'm sick and tired of the hearings. Like, I'm just trying to get it over with. So I'm just trying to, but I don't want to like go rogue, derail. You get what I'm saying?
Correct.
But you get what I'm saying? So what I'm saying is, this is a preliminary hearing?
Correct.
So I'll probably be the best, if I just have somebody represent, probably be the best, yeah. I do it like that. So you said it'd be the 5th?
Yeah, I can put you on for the 5th.
Now let me ask you a question. What if y'all don't get that paper by then? Then what? We got to continue again?
If you don't get his application, what happened?
Well, someone's going to have to talk to you about your case anyway. So if we don't receive the application by then, we'll just take it over the phone when we talk to you.
Okay, that's cool.
Yeah.
So it sounds like you guys will make an appointment and you will call, right?
So why don't we go on the record and put everything on the record that you're going to have a continuance till next week, okay?
Yeah, that's cool.
Okay.
So I am Parole Officer Truscello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing for Reginald Upchurch, inmate number 332491. And today is Monday, October 28th, 2024. This hearing is being conducted at Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Mr. Upchurch, can you just state your name and inmate number for the record, please?
Reginald Upchurch, Junior, 332491.
This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Jones. Can you please identify yourself, please?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit. And I would just indicate that I had conversation with Mr. Upchurch this morning. He's indicating he would like a continuance till November 5th so that the Public Defender's Office can determine his eligibility for public defender services.
Said, okay. Then the continuance is granted, and we will see you next week, okay, Mr. Upchurch?
Can I say one thing though before I leave?
Yes.
So when you see me next week, is it like for the hearing, like do that discuss like what's gonna happen?
You'll have your full preliminary hearing. So you'll speak with your attorney in the next week, go over the charges against you, and we'll go through the whole process for the preliminary process.
No, what I'm saying is is a preliminary hearing, do that determine like what's gonna happen, like what y'all gonna do? Cause I know what revocation is, so I'm trying to figure out what's the difference.
Yeah, so the preliminary, we're just gonna go over the charges and see if there's probable cause for you to stay incarcerated pending the revocation. Revocation hearing is held within 60 days of your business days of the remand. Okay.
I understand.
Okay, and your attorney can explain all the whole process better when you guys talk on the phone, okay?
All right.
All right, thank you, Mr. Upchurch. Have a good day.
Okay, you too.
This concludes the hearing for Reginald Upchurch, inmate number 332491.
Good morning.
Good morning, how are you?
Good, thank you.
Good. I think I just have one with you, right, Mr. Ortiz?
Yes, I have it here. Yeah, he's right here.
Perfect, thank you.
Hello, how you doing?
I'm good. How are you, Mr. Ortiz?
I'm doing good, miss. How you been?
Good. We can't start until exactly 9:30, okay?
No problem, miss.
Do you need the interpreter here today?
No, miss, I don't even interpret.
No interpreter? Okay,
No,
all right, we'll
please.
be with you in a few minutes then, okay?
No problem, miss.
Thank you.
Okay, thank you so much. I got the two or three. First one is United World. The Tobago. You sit in at 10:50. And then back at, and then 15, and the 128 better and then like.
Good morning, my name is Parole Officer Truscello. How are you today, Mr. Ortiz?
I'm doing good. How about?
Good, so we're here for your preliminary hearing. It is Monday, October 28th, 2024, and an attorney from the Public Defender's Office, Attorney Sirica, is here to speak with you, okay?
How you doing, Mr. Ortiz?
Yeah, I remember you.
Yeah, all right, here's what happened here. Your paperwork got here late, and they
Okay.
have not been able to schedule a call
Okay,
since October 24th. So a couple of things you can do. You
okay,
can either ask for a continuance so we can get your paperwork. You can go forward on your own. You do have an obedience to the law charge, correct?
yeah, I got pending charge.
Yeah, and the other option you can do is, as you know, we can't get you to the revocation hearing until your case is resolved in court. I'm not telling you to, but the other thing you can do is you can waive the preliminary hearing because there is a new charge, and then we'll do the paperwork in between, and we'll get an attorney assigned to you. That's up to you, though.
No, because they told me I go next Tuesday to court, and
Yep.
they about to drop it the charge. That's what they told me.
Okay,
That's what my
but
lawyer, the lawyer told me.
that's fine.
They said they're
That's-
about to drop it because they say I got it
No, don't say nothing about your case on the record, Jostiel. That's great. It's going to be taken care of. But
Okay.
we can't get you to the revocation hearing, as you know, until the case in court is resolved.
Okay. you know.
So she needs to know, what do you want to do? Do you want to waive the hearing today?
Yeah, you my lawyer now?
I don't know. It depends on who, I could be, there's 4 lawyers in the office. So why don't we do this? Have her do, you want to waive the hearing today
Yes,
until
yes,
you
sir.
resolve the case in court, right?
Yes, sir.
All right,
Yes, miss.
let her, go ahead.
Okay.
Mr. Sheldon. Let her do some stuff and I'll take care of it for you.
Okay, so I'm just gonna go through a quick speech for you to waive on the record, okay, Mr. Ortiz?
Okay, miss.
All right. So I am Parole Officer Truscello. I'm a hearing examiner for the Board of Pardons and Paroles. And this is the preliminary hearing concerning Jostiel Ortiz, inmate number 3834441. Today is Monday, October 20th, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and New Haven Correctional Center. Please state your name and inmate number for the record.
My name Jostiel Ortiz, 3834441, date of birth 8/10/89.
Great. So, Mr. Ortiz, I did just hear you confirm that you would like to waive today's hearing.
Yes, miss.
Okay, you do not want to move forward and you do not want to continue this for a attorney,
No.
correct? Okay.
No.
Okay.
May I ask you one
Go
question?
ahead.
You did review the file?
I did review the file.
Charge everything's in order?
I do have a,
Okay, I just want to make sure.
there is an obedience to the
Yeah,
law.
I mean, that's pretty straightforward.
They give me a submit. That's what they give me. A misdemeanor submit. They don't give me a
Correct.
bossman. They don't give me
Yeah,
nothing.
it's still a new charge though. So we're gonna do, you're waiving the hearing today. We're gonna get a hold of you, schedule a legal call with you to get the paperwork. So you'll have a lawyer for your revocation hearing, okay?
Okay. And you don't know what date?
No, because you have to resolve the case in court first, and then the parole officer has to send the paperwork in Jostiel that the case is resolved. So if you resolve it next week, it's gonna be about 3-4 weeks after that,
No problem, sir.
okay?
No problem.
All right.
So I'm just gonna take 1 minute, Mr. Ortiz, you're all set because he did not ask for representation today.
No, not for today. He's gonna,
So I'm gonna have him just stay as I go over with Ruth. I've never had anybody.
it's,
Is that it?
yes,
Okay.
it's kind of standard practice. Just so the record is clear, Josh, you're waiving the preliminary hearing today. You're gonna resolve your case in court. In between, we're gonna get a lawyer assigned to you.
Okay.
And then once your revocation hearing gets scheduled, the lawyer will call you and speak. to you.
Yeah, because they cannot. I think they cannot do nothing right now because I got pending charges.
Correct, correct.
That's what I'm saying. Is that
Alright.
I have to take care first till I can see parole again, and you better get a lawyer, and so they they can help me to
Correct.
my process because that's I need I need help. That's what
Yeah,
I
we'll
need.
give, so we're gonna set up a call with you and then we'll get an attorney assigned to you, okay?
Thank you, sir. Have a good
All
day.
right, see you soon.
Okay,
Thank you.
all right, perfect. Thank you, Mr. Ortiz. You're all set.
You know what I'm saying? Thank you.
Have a good day.
miss. And I have to see you. I have to see you next time.
Yes, well, after you resolve the case, you gotta see the hearing examiner.
Yeah,
Thank you. Have a good
all
day.
right. Thank you. This concludes the hearing for Jostiel Ortiz.
Yeah, I'm not trying to.
After the line. I'm going to speak. Entonces,
Yeah, no problem.
I just let it know.
Good morning.
No video. Oh. Okay, go ahead. Good
Good
morning.
morning. Mr. Salaberrios, we have to wait till exactly 10 o'clock to start, okay? So give us 2 minutes.
Okay.
They'll make me record you. Okay, Mr. Salaberrios, your attorney just wants to speak with you quickly, okay?
Hi, Mr.
Okay.
Salaberrios. How are you, sir?
I'm okay.
So my name is Robert Famiglietti. I'm a public defender from the same office as Ms. Dean, Attorney Dean, that spoke with you. So I'm going to be just handling your hearing for today, okay?
Okay.
All right. Do you have any questions?
No, I didn't
Okay.
receive the violation package or anything.
Okay, we're going to get to that. Did you receive the notice of the charges?
Yeah, the violation.
That's what you got.
Okay.
We are just gonna wait until exactly 10 and then start, okay?
Okay.
All right, thank you. So good morning, my name is Parole Officer Truscello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Noel Salaberrios, inmate number 268936. Today is Monday, October 28th, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Bridgeport Correctional Center. Please state your full name and inmate number for the record.
Noel Salaberrios, 268936.
This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti. Can you please identify yourself for the record?
Yes, good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit, sir.
This is a preliminary hearing which has 3 purposes under Connecticut law. The first is to determine if there is probable cause to believe you committed an act that violated the conditions of your parole. Second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. Today's testimony will be taken under oath. So, Mr. Salaberrios, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure of the hearing. First, I'm going to read you your rights, and then we are going to review the parole violations that were charged against you by the state, your parole officer. Then I will review and identify the exhibits filed for the record. And the state is not present at today's hearing. However, you will have the opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
Great. So you do have rights for this hearing. And I'll review all of them with you now. You have the right to be represented by an attorney at this hearing, and yours is present here for you. You have the right to receive written notice of the charges of violation. Did you receive written notice of the charges?
Yes, I did.
Yeah, you were just commenting that you didn't receive the packet, correct?
Right.
Okay. I'm just going to make note of it, okay?
Okay.
You have the right to review the evidence against you before the hearing. You have the right to submit evidence in support of your case. And at this hearing, you have the right to call and examine voluntary witnesses to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
So we're going to go over the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So for charge number 1, obedience to the law, the charging officer reported that on October 14, 2024, you had contact with Derby Police Department. It was reported you were waving a knife around and intimidating everybody in the home located at 8 Anson Street, Elvira's residence. As a result of your actions, you were arrested by Derby PD and charged with the violation of Connecticut General Statute 53A-62A1, threatening second and physical threats, and Connecticut General Statute 53A-96, unlawful restraint second, 53A-64CC, criminal attempt to commit strangulation, suffocation third, 53A-64, reckless endangerment second, and assault third. On charge number 2, the conditions of general no contact with, the charging officer reported that on October 14, 2024, you had contact with Derby Police Department. It was reported that you were waving a knife around and intimidating everybody in the home, including ES, who you have a general no contact with. As a result, you are in direct violation of the Board of Pardons and Paroles general contact stipulation condition. The state has filed the following exhibits that have been pre-marked for identification purposes. Exhibit A is the Connecticut Conditions of Parole. Exhibit B is the Connecticut Board of Pardons of Parole Remand to Custody Order. Exhibit C, the Notice of Parole Violation. Exhibit D, the Parole Violation Report. Exhibit E, Derby PD Police Report 24-8980. And Exhibit F, the Judicial Pending Case Details. Did you receive the notice of parole violation report, and all the other documents I just marked for identification purposes?
I did.
No.
He did. I did.
No.
He did not. He received the notice form,
Okay, so
which is what he's required to receive at this point.
correct. So we are okay to still move forward without the evidence?
I have the evidence,
You have
so I believe we are fine to go forward.
I don't have the evidence. I don't know what the evidence is. I haven't been able to look over it.
That's what happens at every preliminary hearing, sir. They're not provided with those forms. In my experience, and at every single preliminary hearing, all a defendant is provided with are the charges against them, and their counsel is provided with all the other documentation. Now,
Okay.
you would
So
like,
I'm requesting that I would like to see the evidence and go over it myself so I could properly defend myself.
okay,
Because you're only sitting here temporarily and you're not my lawyer. So
Okay.
I haven't
So-
received it, so I don't know what you're gonna say. I don't know what I need to defend myself about. You wasn't there.
well, let me just explain what I believe Attorney Dean was trying to explain to you. If a judge set a bond in your case, which a judge did, okay, he or she at the arraignment found probable cause. All this hearing is for is a preliminary due process hearing to see if there's probable cause to continue to hold you without bond and go forward with the next hearing once your charge is in court. So in other words, were you remanded for absolutely no reason, or were you remanded because a judge found probable cause and you were arrested? And the answer to that question is your parole officer did not remand you for no reason. There was a reason. Now, you're still presumed innocent, and you still have your presumption of innocence to fight the charges in court and to fight these allegations at the next hearing, the revocation hearing. But this is just a preliminary due process hearing to make sure that they didn't just remand you for no reason. Now, you may
But
disagree with me.
in the meantime, I'll be held on a DNR with no bond.
Correct.
So, all right, so I would
That's
like
the
the
process.
opportunity to see the evidence for that.
Before
the
the
same
revocation
thing.
hearing. Before the
Okay, but there's
revocation
still
hearing.
the potential to where maybe they don't put the DNR and I could bond
No,
down, have
that's
a
not,
better.
it's not a possibility, sir, because the judge already found probable cause, and the regulations and statutes say if a judge has found probable cause, this hearing examiner, what she's going to say in the next 5 minutes, is that she can't change the judge's finding at this hearing. So that's why we were trying to get you to waive the hearing, because it's a foregone conclusion. There basically is no basis for you to challenge the DNR because it was already decided by a judge of the Superior Court. Okay? I'm going to send you today, if that's okay, Exhibit E, wait a minute, let me finish my sentence. Exhibit E, which is a copy of the police report. Now, I don't have to send that, but would you like me to send it?
Yeah, I want the whole packet.
Okay. I'll be sending you the police report at least, okay? And we'll take it from there. But we're going to let the hearing go forward now. At least that's what you should do, okay? Because otherwise it's just going to delay everything. Do you want a continuance of this hearing for you to get the packet, to be able to review the packet, even though it's going to be a conclusion of probable cause because the judge already made a finding?
Yeah, I want to get the packet and continuance.
Okay, so we're gonna, on the behalf of the defendant, we're gonna be asking for a continuance of the preliminary hearing. Now, the 14 days, we're gonna pass. You have a right to have this hearing within 14
Right.
days, and you had it today within 14 days, but you're gonna waive that 14-day defense because you want the information, and I'll send you the packet today.
Yes, that'll work.
Okay, so that's what you want.
Yes,
So we'll have another preliminary hearing in the future, probably a couple weeks from now, okay? To allow you time to review the packet and speak with Attorney Dean about what you think your defenses are.
okay,
And that way you'll also get a copy of the police report that you can talk with Attorney Dan Lage, your public defender in Derby, in the Derby court, okay? To talk to him about that case and defend yourself in that case.
yes, that
All
sounds
right.
good.
Have you been served with a violation of probation warrant yet?
No,
Okay, that's a possibility too.
and I understand.
What we want to say today is, we want your parole officer to amend this PBR to add what's going to be the forthcoming probation violation on behalf, based upon this same conduct. 'Cause we don't want you to get violated again in the future. So as for the record, because they could do it twice if you get served with the warrant later, and it would waste your time. So what we want to do is lump all of this together in one revocation rather than remanding you again. So I'm going to hand the judicial printout of the docket number that we believe you're going to be violated on, because you were on probation as well as parole when this allegedly happened. So it's docket A05D CR 22 190328S. We're asking that the parole hearing examiner request the parole officer who wrote the PBR to amend the PBR when you're served with this warrant to get it all done at once. Okay? That's just a request we can make. They don't have to do that. But rather than them doing this all over again, once you get released for this violation and then hitting you with another warrant, we don't want that to happen.
Right, I'd rather all of it come together.
Okay, and that's why I'm doing that today, handing that to the hearing examiner, okay? So we would like a continuance today.
Okay, all of that is noted, and I will grant the continuance. The hearing will be held on November 19th, okay?
Okay,
And we will get a packet to you in the meantime.
all
Okay?
right.
All
Thank
right?
you.
No, thank you. So this concludes the preliminary hearing for today's date for Mr. Noel Salaberrios.
Thank you.
All right, you're all set, Mr. Salaberrios. Hello.
Good morning. I have Altman here for you.
Okay, great.
And we're gonna go down the list that's online, correct?
After Altman, can I have Albert, please? And then we can go down the list.
Okay, so far I have Gonzalez.
Well, whatever. That works too.
But
That's fine.
if Altman's not here before, then I'll have to just send in Gonzalez if that's okay.
Albert, that's fine. Yeah, no problem. We'll check in when
Okay.
we're done with Mr. Altman. Thank you.
Okay, you're welcome.
Mr. Altman, we'll be with you in about 3 or so minutes once everybody's here, and it's 10:30 exactly, okay?
Yes, miss.
All right, thanks.
Are you Miss Jones?
No, I'm Officer Truscello.
Okay.
Yeah, Miss Jones should be on her way over, so she should be here soon, okay?
Yeah, no stress.
All right, thanks.
Okay, so, in about 10 minutes, not 10 minutes, if run down here, they want it next, it will be like number 6. Okay. Okay. No.
Here now. Okay, so good morning. My name is Parole Officer Truscello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing concerning Brian Altman, inmate number 409527. Today is Monday, October 28th, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Ryan Michael Altman, 409524.
This is a public hearing, and public access to this hearing is available via video live stream. And present this morning is Attorney Jones and Parole Officer Babich. Can you both identify yourselves for the record? Parole Officer Babich.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Altman. And if I can just indicate for the record that I was not able to speak to Mr. Altman until this morning, so I will need to schedule a follow-up legal call with him to go over the charges and possible defenses. And so I'd be asking for a continuance to November 19th. I believe that is an available date for you.
Perfect. And Mr. Altman, you're okay with all this as well?
Is that work for Ms. Babich?
Yes, she indicated that that's okay for her.
Yes. Perfect. So we're going to continue the case for Ryan Altman to November 19th, 2024 for his preliminary hearing.
Thank you.
All right, you're all set, Mr. Altman. Thank you.
And Ryan, I'm going to email your counselor to set up the next call, okay?
Thank you all.
Okay, all right.
Have a good day, Mr. Altman.
Yep, you too. Just knock on the door or something.
You're waiting for, yeah. Perfect. Thank you.
Someone's gonna come in. So weird, you guys looking at me. They look at me. I'm crazy.
Yes, ma'am.
Hi, I'm waiting on Albert, but I have Gonzalez.
Okay, I don't have Gonzalez's attorney, so
Okay.
I don't know.
Okay.
You
Wait
can
a few
send
more
him.
minutes.
Yeah, you can send him in. I think there's his attorney. Go ahead, you can bring Gonzalez.
Okay.
That's fine. Thank you.
Okay.
Good morning. Good morning. I am Parole Officer Truscello, a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Angel Gonzalez, inmate number 206144. Today is Monday, October 28th, 2024. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Please state your full name and inmate number for the record.
Angel Gonzalez, 206144.
This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti. Can you please identify yourself for the record?
Yes, good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
Hello.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. And the state, not you, has a responsibility to prove the allegations by a preponderance of evidence that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction.
Yes.
My recommendation will be given to the panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will provide to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath, so please, Mr. Gonzalez, can you raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, has brought against you. Then I will review and identify the exhibits filed for the record. The state is not present at today's hearing. However, you will have an opportunity to present any relevant testimony and any relevant documents. After the consideration of all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have the opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin? You say no out loud, please.
No.
Thank you. You have some important rights to this hearing, and I'm going to review them with you now. So you have the right to be represented by an attorney, and counsel is here to represent you. You have the right to receive written notice of the charges of violation. Did you receive the notice?
Yes. Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. And at this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand all these rights, and are you ready to go forward?
Yes.
Thank you. So we are now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. On charge number 1, condition of absconder, the charging officer reported that you were released from the January Center to the Open Hearth Halfway House on July 26, 2024. You did not return to the halfway house, your only parole-approved residence, on August 7, 2024, when you were out on a pass to attend problem sexual behavior treatment. You made no attempt to communicate with or contact the halfway house or your parole officer, and your location in the community was unknown. On charge number 2, condition of halfway house placement, the charging officer reported that you were transported to and placed at the Open Hearth Halfway House upon your discharge from the January Center on July 26, 2024. You were aware that the Open Hearth Halfway House was your only parole-approved residence, and you failed to return from the community pass to attend problem sexual behavior treatment on August 7, 2024. Your whereabouts in the community have been unknown since. The state has filed the following exhibits, pre-marked for identification purposes, as Exhibit A, the remand to actual custody, Exhibit B, the notice of parole violation, Exhibit C, the parole violation report, Exhibit D, the parole statement of understanding conditions of parole. The signed statement of understanding conditions of parole. Exhibit E, the halfway house agreement. Exhibit F, the Open Hearth Halfway House incident report. In addition, the state has filed an addendum to the parole violation report on September 6, 2024. That is also admitted into evidence and reads as follows. In reference to the parole violation report submitted by P.O. Huff regarding Angel Gonzalez, inmate number 206144, the following applies. On September 3rd, 2024, the Board of Parole issued a warrant based on the report, declared Gonzalez an absconder from special parole supervision. On September 4th, 2024, the case was assigned to Parole Officer Pinto for investigation. And on September 5th, 2024, Gonzalez was apprehended by the Parole Fugitive Investigation Unit. A remand to custody order was lodged with Hartford Correctional Center on September 5th, 2024, as approved by P.S. Waldron. On September 5th, 2024, Gonzalez was served his parole violation notice and parole rights at the Hartford Correctional Center. The signed notice of parole violation, parole rights, remand to custody, and arrest report are scanned into evidence in the case notes on September 6, 2024. Mr. Gonzalez, did you receive the parole violation report and notice and report and all the other documents I marked for identification purposes?
Yes.
The defense has filed the following exhibits as well. I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Do you and your client need any additional time to submit any?
No, we do not.
Today we have no witnesses. So now is the defense's opportunity to call witnesses, present evidence, and speak to any evidence submitted.
Because there was a absconder warrant, we have no comment as to the preponderance standard.
Just gonna review the my evidence quickly, and I'll let you know my finding. So for charge number 1, I do find that you violated the condition of absconder based on evidence provided in support of the charge. That's Exhibit C, Exhibit D, and Exhibit F. On charge number 2, I find that you violated the condition of halfway house placement based on the evidence provided in support of the charge, which is Exhibit C, Exhibit D, Exhibit E, and Exhibit F. So that concludes the fact-finding portion of the hearing. Before I make my recommendations, counsel, you have the opportunity to speak on your client's background and history.
Just briefly, I have 2 questions for my client before I go into my argument. Sir, how long were you at the January Center?
From March until what they sent me to the open heart.
July, I think.
Yeah.
Yes, March, April, May, June, July. And how long have you been on parole, sir?
Since they released me.
I don't know when that was. How early were you on parole? Was that just recently this year or before March?
This year.
This year, March. So you've been on parole since March.
Yes.
So this is your first violation of parole, correct?
Yes.
Okay. So my client basically left parole. He was gone for just a month. There was absolutely no arguments, no struggles, nothing with him. He completely cooperated coming back into custody. He had absolutely no issues whatsoever other than his leaving, no misconducts, no graduated sanctions. And he performed perfectly at the January Center in treatment. My client's very mature, he's intelligent, and he's very insightful into the issues that they're discussing both at the January Center and what they were attempting to communicate at this new treatment regime. My client had a disagreement on the topics, the risk factor definitions, the change in methodology. He felt challenged. It was a group setting. It was very embarrassing, and he got depressed as a result of this. He had been doing so well in treatment at the January Center, came to this new placement in Open Heart. Open Heart wasn't the problem, but the treatment modality and methodology was the problem. And unfortunately, rather than he found resistance to trying to change that, and he unfortunately left. He was only gone for a month. There were no new crimes, certainly no crimes of violence. He's not a threat to the community. He's been sitting in jail now since September 4th. He's a single 54-year-old male. He receives his support from his mother and stepfather. He has 3 adult daughters and 5 grandchildren. He obtained his GED in 2000 while incarcerated. He had worked at a 13-hour job with neighborhood ambassadors in the past, waiting out for a list for additional assignments through them. He worked doing landscaping in his history, painting, roofing, loading shingles and dumping them at a landfill. He worked recently at the American Job Center and was about ready to secure a job at Valvoline as a technician. He has an excellent work history. He's on the waiting list for a job while incarcerated. When released, and we're hoping that that's very soon, he would like to return to the Open Heart halfway house. He's also interested in joining an apprenticeship for either welding or steel work and interviewing again at Valvoline. His cousin is an electrical contractor that can also provide him with an opportunity. This is a very minor violation. It certainly doesn't require the type of revocation, total revocation, I believe, that his PO is recommended. My client's going to be on parole until 2028. This is a basic violation. There was a reason for it. It was thought out. And we'd ask that he be released in early November. Thank you for your time and consideration.
Thank you.
You're welcome.
Okay, so I am just gonna review the evidence submitted, and I'll have to listen to testimony too, and then I'll get back with you to make my recommendation.
Yes, ma'am.
You, this record. So, like one more thing. So I have listened to testimony and I reviewed the evidence provided. And based on that, I am going to recommend that your parole be revoked, Mr. Gonzalez, and that you serve an approximate 5-month period of confinement as a sanction with a parole date of February 5th, 2025. And I recommend the following conditions: no contact with your victim, GO, no contact with minors, mental health treatment, problem sexual behavior treatment. Did you mention if he'll need a halfway house?
Yes, open heart is what he's asking. So Hartford, correct, sir?
That's where he left from? No?
Well, yes, that's where
what's available?
that's what he would like, to be in the Hartford and open heart. He had no problem with the halfway house. It was the methodology of treatment. So hopefully they can find a different treatment opportunity where they can at least speak with him about it.
Yeah, okay. So those are my findings and recommendation. Oh, so I will do half houses. So one more time, no contact with your victim, GO, no contact with minors, mental health treatment, problem sexual behavior treatment, and halfway house placement. So my findings and recommendations will be forwarded to the board on November 7th, 2024, and you should receive written notice of a written decision from the board following that date. The board may lessen my recommended sanction or they may let my recommended sanction stand, or they may impose a sanction longer than what I've recommended. If the board decides to impose a sanction longer than what I've recommended, then a supplemental hearing will be held before the hearing. The board will send you notice of that supplemental hearing information. And they'll give you notice about the documents and the specific reasons why they want to have that supplemental hearing. During the supplemental hearing, you will also have the opportunity to respond to those specific reasons in front of the panel. Do you have questions, Mr. Gonzalez?
Sure. Chances are they're not going to have a supplemental hearing. It's only happened 2 times since I've ever been here.
Yeah.
So what's going to happen is November 7th, the board's going to meet. Okay, they can either accept the February date as a release date, they can shorten it, or there's a very small possibility they lengthen it. But the board's decision will be final, okay? So right now, your release date, suggested release date is February 5th, okay? That's what our recommendation is.
2025?
Yes.
Okay, I thought you said I was going to stay here to 2028.
No, I could have.
No.
Oh.
2025, so 5 months from September is the recommendation. They can always shorten it, and I don't think they're gonna lengthen it. What you should do is call me on the 8th.
Well, I don't have your number.
Okay, well, ask your counselor to call the parole defense attorneys, okay? So we'll be able to tell you what happened on the 7th.
Okay.
They're gonna mail it to you.
Okay, so my release date as of now is February what?
5th.
5th, okay.
Yeah, okay, sir?
All right, thank you very much.
You're welcome. Have a good day, sir.
This concludes the hearing for Angel Gonzalez. You're all set, Mr. Gonzalez. Thank you.
You're welcome.
Mr. Albert, we'll be right with you. I just have to call your PO and get her. Oh, she's online. Hi, Officer Schaefer, are you here?
Yes, I'm here.
Perfect. But never mind. All right, then we will get started now. Good morning. I am Parole Officer Truscello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Daniel Albert, inmate number 361570. Today is Monday, October 20th, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Please state your full name and inmate number for the record.
Daniel Albert, 361570.
This is a public hearing, and public access to this hearing is available via video live stream. Present this morning are Attorney Famiglietti. Got it right all day. Go ahead, Mr. Famiglietti.
Public defender.
Everybody has a terrible time trying to pronounce his name. How do you spell that again? I'm like family and Getty.
That's actually
Famiglietti.
helpful. Famiglietti.
That's right.
Absolutely. Go ahead, Attorney
Famiglietti. And Public Defender Robert Famiglietti of the Parole Defense Unit. Good morning, sir.
And
How
also
you
present
doing?
is
Good.
Parole Officer Schaefer. Can you please identify yourself for the record?
Parole Officer Schaefer, State of Connecticut, Waterbury District Office.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. The recommendation will be given to the panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that the revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. The hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Albert and Officer Schaefer, can you please raise your right hands? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Yes.
Thank you. So we're going to go over the procedure for the hearing. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, has brought against you. Then I will review and identify the exhibits filed for the record. The state will have the opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will then have the same opportunity. After the consideration of all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. And after the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
Thank you. So we're going to go over the rights for your hearing today. You have the right to be represented by an attorney at this hearing, and counsel is here for you. You have the right to receive written notice of the charges of violation. Did you receive that notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. And in addition, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
We're now going to review the charges of the, that the state, your parole officer, is bringing against you and the information underlying each charge. Officer Schaefer, can you please read charge 1, the condition of obedience of law, what you reported?
Charge 1, obedience to law. On August 7th, 2024, you engaged in an argument with the victim over relationship issues resulting from a threesome you had with the victim and her friend. During the argument, you covered the victim's mouth with your hand because she was yelling, then spit on her, slapped her in the face, and pushed her to the bed. You then shut off her phone and told her she was not allowed to call for a ride because you wanted her to spend the night. You then told her she is not to tell anyone of the incident or you would have a female friend attack her, and that you are a Latin King gang member and she needed to respect you. You were subsequently arrested on 8/13/24 and charged with 1 count breach of peace in the second and 1 count threatening in the second.
Thank you. The state has also filed the following exhibits pre-marked for identification purposes. Officer Schaefer, can you read the exhibits you've submitted for evidence?
Give me 1 second. I apologize. Hang on.
That's okay.
Hold on. I'm looking.
I can do it if you don't have it
Yeah,
available.
if you can.
Okay.
Yep, please.
So the state has filed the following exhibits pre-marked for identification purposes. That's Exhibit A, the remand to custody order. Exhibit B, parole conditions.
Just found
Exhibit
it, yep.
C, parole violation report. Exhibit D, the notice of parole violation. Exhibit E, the Waterbury Police Report case incident report number 24000720038. And the arrest warrant application, police case number 24000720038. In addition, the state has filed an addendum for the parole violation report on October 2nd, 2024. Officer Schaefer, do you have that available?
Yes.
Please read the addendum you submitted.
No, I didn't print that out. I apologize.
I have it too.
Yeah, thank you.
You want me to read it? I'm sorry.
Yes. Yep,
Oh,
please.
No problem. The addendum submitted was on October 2nd, 2024, and that reads that on October 1st, 2024, under docket number U04W CR24 0510373-S was disposed of. 53A-181 breach of peace second was dismissed, and 53A-62A1 threatening second physical threat was dismissed. Please proceed with the revocation hearing. Mr. Albert, did you receive the notice of parole violation, the parole violation report, and all the other documents I just marked for identification purposes?
I got this.
That's it.
Yes, he got the information.
Perfect. And then in addition, I did receive the defense exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you and your client need any additional time to submit any additional evidence?
No, we do not.
Thank you. Today we have no witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. Officer Schaefer, do you have any, do you wish to testify on the charges you brought against Mr. Albert?
Yes, I just would like to say that Mr. Albert does have a history of violating protective orders and threatening. So I thought this arrest was significant. All the charges were dismissed, as we did just identify. I don't have any witnesses in this or any further additional information other than what was presented in the violation report.
Thank you. And it's now the defense's opportunity to call any witnesses, present evidence, and speak to the charge submitted.
Yes, regarding the preponderance of the evidence standard, these charges were dismissed. The victim did appear in court, gave a statement. I just received a copy of the statement from his defense attorney today. Didn't have time to put it into evidence, but essentially the state prosecutor nollied the charges, and then at the request of the defense, because under the no factual basis prong, the charges were dismissed. They made a finding that there was no factual basis for the charges to go forward. The victim was not the complaining witness. It was someone else that called the police, one of the other parties that was mad at the defendant. They admitted lying about the allegations. And so the charges were dismissed. The defendant, and so those are my comments as to the preponderance of the standard. I don't believe of the evidence. I don't believe a finding, there's enough evidence or any evidence for the finding to be made. Thank you for your time and consideration.
Thank you.
You're welcome.
Okay, so I'm just gonna take a moment to review the evidence that was submitted before I make my finding. I'm actually gonna take a recess just to go review this quickly, and I will be back on the record shortly, okay?
Okay.
Thank you.
Okay.
Should be another one before him.
I didn't know I could bring witnesses.
We're still connected to the live stream, sir. Just hold on a moment.
Okay, yeah,
You
they,
can just wait for the officer to return.
all right, yeah, they all would have came, both the girls. My friend, my boss, my breach counselor.
See, that's the right now. Sorry, we put it.
All right.
Can you hear us, sir?
Can you hear us? Okay. All right. So I am going back on the record now. And I will be going over the findings. So I do recognize that the charges of breach of peace second and threatening two were dismissed. However, I do not feel like it negates the behavior that occurred. So I do find that for charge number one, you violated your conditions of obedience to law based on the evidence provided in support of the charge. And that's Exhibit B, Exhibit C, Exhibit E, and Exhibit F. Specifically in Exhibit F, there is a statement from the victim that states that you slapped her in her face, spit on her, and pushed her onto the bed, which does meet the elements of the crimes. In addition, Officer Schaefer mentioned that there is a history. So that is my finding. And that concludes the finding portion of the hearing. So before I make my recommendation, the state will have the opportunity to speak to your background and history. And after the state is finished, you'll have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. So Officer Schaefer, you are now, do you wish to make a statement regarding Mr. Albert's violation, background, and history at this time?
Well, like I said, as far as the history goes, he does have a history of threatening and violating protective orders. At the same time this case was going on, he had a simultaneous case going on, which received an unconditional discharge for threatening in the second. While he's been on parole, he has been compliant outside of these new charges. He hasn't received any misconducts, and he was working. So those are some good things about Mr. Albert there. But again, just to go back on what we're here for the violation, I just feel that this pattern is what is to be noted.
Yeah. And counsel, do you wish to make a statement regarding Mr. Albert's violation, background, and history?
Yes.
Thank you.
A court and a prosecutor dismissed these charges in their experience and their duty to protect the society, dismissed these charges because the victim admitted she lied. What happened in my client's... Sir,
thank you.
Listen. What happened in my client's past has no bearing on whether or not something in this case happened. It's illogical to conclude because something's happened in the past that this incident occurred. That's illogical. There's no basis to conclude that this occurred. My client is 32-year-old male. He's single. He receives his support from his boss, family, and friends. My client attended Cheney Tech School where he studied welding. He worked full-time at Parole Gas, full-time at Furniture Factory Warehouse, and was working detailing on the side with a friend at the Right Touch LLC. He would work an hour or two after work there, so he was working 2 jobs. He participated in the Explore program. He completed 23 of 26 sessions. Excuse me. He completed Explore in the past in 2020. He also worked with Hang Time, which is a 2-hour gathering held at our Bridgeport, New Haven, and Waterbury locations. Participants with a safe and respectful space to openly discuss their experiences and challenges with similarly situated individuals and connect to essential services. They were assisting Mr. Albert obtaining clothing and equipment for his job at Parole Gas. He was on a maximum contact schedule with good regularity of contact. He was receiving medical assisted treatment. He wished to be placed in a halfway house in Waterbury. He had absolutely no sanctions and was compliant with parole, and the charges were dismissed. He can return to the Furniture Factory Warehouse to work, and after he's settled in the community, he'd like to return to Parole Gas, and he's always able to do the detailing job. I'm requesting that he be released on November 7th. There's absolutely no basis and no reason to hold him any longer. He's been incarcerated now since August 13th, 2024. And I'm not sure if he's had any prior violations of this parole before. I don't believe he has.
Last time I got early termination. This is the first time I was able to capture my exes on film. This is the only reason this got dismissed. My domestic history was on the basis of being with two older women that know the system, and once they don't get their way, you know what happens. In all of my relationships, besides these two older women, I've never called it domestic. And the whole reason this one happened was because my girl tells her friends my name. Okay, if it wasn't for that, then we wouldn't be here. Oh, he's on the bracelet. Let's lock him up.
There's absolutely no basis to further incarcerate my client. Thank you.
Thank you. So I have listened to the testimony and I've reviewed the evidence submitted. And based on that, I do recommend that your parole be revoked and then you serve an approximate 3-month sanction which is a re-parole date of November 13th, 2024. And I recommend the following conditions: no alcoholic beverage consumption, behavioral management program for domestic violence, no contact with your victim TG, a general no contact with TE, halfway house placement, and you mentioned Waterbury, correct?
1 second. You mentioned you wish to be placed in Waterbury, correct?
Yes.
Okay.
Okay.
I have my protective order is fully dropped and I'm currently still with TE. She's like, that's.
There's no charges.
Yeah, we're engaged. Yeah, we're engaged. Like, that's not.
You're not, so are you ordering no contact with TE?
A general no contact with TE without PO's permission. I can.
So you can't contact TE unless your PO gives you permission, sir.
Because you're in.
That's an order of parole. That's their recommendation. It's not an order of the court, but you still have to obey that.
So what?
It means that when you're on parole, you can't contact TE without your prior permission of your parole officer, even though you're engaged.
So she has to contact you guys?
No,
what do we do?
no, what I just said. You have to contact your parole officer.
Okay.
And ask if you can have contact with her. Not
Okay.
every time you have contact with her, but you speak to your parole officer when you're released and you say, hello, the charges were dismissed. I wish to have contact with my fiance. She wants contact with me. What is your position? And if the parole officer says no, you call an attorney.
Okay.
But you call a private attorney. Okay.
All right. Also, I have a second question. I was kind of judged on this narrative of this case when I got released from the halfway house to Reach.
What's the question?
I heard I was kicked out of Reach indefinitely.
I don't know. I don't know if you've been kicked out of Reach. Your parole officer advised.
Okay.
Your parole officer, when you're released on the 13th, if the board goes along with this, the board still has to adopt this recommendation. And I think they're meeting on the 7th.
They are meeting.
So on November 7th, the board will meet. If they adopt these recommendations, your parole officer will contact you and you'll do what he or she tells you to do, period.
Okay. All right. That's fair.
All right. 1 minute. She may need to say something to finish the hearing.
So yeah, I'm just going to conclude the hearing, okay? So just finding my recommendations, they will be forwarded to the board as your attorney just stated on November 7th, 2024. And you should receive the official written notice from them shortly after. And just so you're aware, the board may lessen the recommended sanction. They may let the recommended sanction stand, or they could impose a longer sanction than what I've recommended. If they want to do a longer sanction, there's something called a supplemental hearing, but you will be notified before that and the reason for it as to why they want to revisit the sanctioning, okay?
Okay.
Any questions now?
So what you should do is call us on November 8th.
Okay.
Or have your girlfriend call us on November 8th.
All right.
And
We'll
we'll tell you what happened on the 7th, okay?
Okay.
All right. Good luck, sir.
All right. Thank you.
This concludes the revocation hearing and I'm going off the record. All right, you're all set, Mr. Albert. Thank you. Thank you, Officer Schaefer.
Thank you.
Good morning. It is still morning. Good morning. I'm Parole Officer Truscello, a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Jerris Holloway, inmate number 424552. Today is Monday, October 28th, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Jerris Holloway, inmate number 424552.
This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti. Can you please identify yourself for the record?
Yes, Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
How you doing today?
Good, sir. How are you?
Good, hanging in there.
This is a revocation hearing to determine whether you have violated the conditions of your release, and I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to the panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. So, Mr. Holloway, can you, the testimony at today's hearing will be taken under oath. So can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth. So help you God or upon penalty of perjury?
Yes.
Thank you. We're going to go over the procedure of the hearing. So first, I'm going to read you your rights. Then we'll review the parole violation charges that the state, your parole officer, has brought against you. Then I will review and identify the exhibits filed for the record. The state's not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. The state, after the consideration of all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose of procedure before we begin?
No, ma'am.
Thanks. You have the important rights at this hearing, and I'm going to review them with you now. You have the right to be represented by an attorney at this hearing, and counsel is present for you. You have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes.
You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. In addition, you also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
We're now going to review the charges that the state, your parole officer, has brought against you and the information underlying each charge. Just bear with me. There is quite a bit of reading, okay? So on charge number 1, condition of reporting, the charging officer reported that on March 25th, 2022, you were directed to report to the parole office for regular reporting on April 27th, 2022, and you failed to report on April 27th, 2022. Report, and failed to make contact with your assigned parole officer. On charge number 2, GPS, the charging officer reported that on April 13, 2022, at approximately 1:34 p.m., you cut the strap of your GPS unit and you removed and discarded the GPS unit in violation of your GPS monitoring agreement. For charge number 3, condition of residence, the charging officer reported that you were reinstated on special parole supervision and placed at Watkinson Halfway House, which was subsequently your only parole-approved residence due to the lack of valid sponsors in the community. On April 13, 2022, you left the halfway house without permission or authorization to do so at approximately 1:34 p.m. and never returned. Your whereabouts in the community were unknown. On charge number 4, condition of absconder. On April 13, 2022, you absconded from your parole-approved residence. You had failed to reside in your only parole-approved residence, the walk-in halfway house, Watkinson halfway house since April 13, 2022. And on April 13, 2022, at approximately 1:34 p.m., you left the halfway house without permission and have not returned. Your whereabouts in the community are unknown at this time. Charge number 5, condition of obedience to the law. The charging officer reported that on July 23rd, 2024, you were arrested by the Hartford PD for interfering with an officer. That's Connecticut General Statute 53A-167A. On charge number 6, condition of drugs. The charging officer reported that on March 28th, 2022, you provided a urine sample for toxicology testing, and the sample tested positive for the presence of cocaine. Charge number 7, condition of halfway house placement. On April 13th, 2022, you absconded from your only parole-approved residence. You have failed to reside at your only parole-approved residence, the Watkinson halfway house, since April 13th, 2022. Your whereabouts in the community are unknown at this time. On charge number 8, condition of problem sexual behavior. On March 29th, 2022, the contents of your personal cell phone were reviewed, and during the review, it was determined you violated the computer access agreement you signed on March 10th, 2022, in coordination with receiving treatment for problem sexual behavior. You violated this agreement by participating in social media sites, apps, and accessing sexually explicit. Nothing. Okay. The state has filed the following exhibits pre-marked for identification purposes as Exhibit A, the parole conditions, Exhibit B, the remand to actual custody order, Exhibit C, the notice of parole violation, Exhibit D, the parole violation report, Exhibit E, GPS monitoring agreement, Exhibit F, computer access agreement, Exhibit G, the attendee event history and attendee EM manager, Exhibit H, community solutions incident report dated April 13th, 2022. Exhibit I, the community solutions abscond report dated on April 13th, 2022 and signed on April 15th, 2022. Exhibit J, the state of Connecticut DOC PCS RSU discharge plan from Watkinson House dated April 15th, 2022. Exhibit K, the misconduct report dated March 28th, 2022, cocaine. Exhibit L, the Redwood Toxicology Lab urine results collected March 28th, 2022. Exhibit M, the misconduct report dated March 28th, 2022, computer access agreement violation. Exhibit N, photographs from offender's phone, 5. And Exhibit O, Hartford Police Incident Report number 24-018927. In addition to the state has filed 2 addendums for the parole violation notice. The first was on July 26, 2024, which reads in reference to the parole violation report submitted by P.O. FAM regarding Jerris Holloway. Sorry, the following applies. On June 1st, 2022, the Board of Parole issued a warrant based on the report declaring the offender an absconder from special parole supervision. On June 14, 2022, the case was transferred to FIU for investigation. On July 23, 2024, Hartford Police arrested Holloway for interfering, 53A-167A. A remand to custody order was lodged with Hartford PD, and Holloway has a court date of August 28, 2024 under docket number H14H, CR 2407652661S. On July 24, 2024, at Hartford Correctional Center, Holloway was served his parole violation notice, and he was provided his parolee rights. The signed notice of parole violation, parolee rights, and remand were scanned into case notes on July 26, 2024. The second addendum was submitted on October 3rd, 2024, and states that on September 26, 2024, Holloway appeared in Hartford Superior Court, G14, under docket number H14HCR 2407652661S. And at that time, Holloway pled guilty to interfering and was sentenced to unconditional discharge, KPH. Mr. Holloway, did you receive the notice of parole violation report, and other documents I just marked for identification purposes? And Attorney Campbell?
Yes, ma'am. Yes, ma'am.
Perfect. The defense exhibits that have been filed so far is Exhibit 1, a list of parolee accomplishments and future plans for parole reinstatement. You mentioned you have.
This is going to be Exhibit 2, please. It's a character reference letter from Roberto Peraza his significant other who he's been in a relationship with. I just have an email to show you that we received this at 8:51 this morning from his defense attorney, and he received this on Friday.
Thank you.
So this is as soon as we could have gotten this to you.
Yeah, absolutely.
I just asked that that be entered into evidence. It's just a letter of support. She wasn't a victim or anything like that.
Okay.
Thank you.
Thank you. Any other additional evidence you need a continuance for to provide anything?
We do not.
You're good to go forward? Okay.
Yes, I am.
Today we do not have any witnesses. So at this time, it is now the defense's opportunity to speak to the charges.
Yes, we have no comment as to charge 1, charge 2. As to charge 3, I don't believe it meets elements under the residence portion, as I don't believe he established a new residence. There's any proof of that. No comment as to the absconder due to the warrant. No comment as to obedience to the law. I will say that the only basis of the unconditional discharge in the plea was that he gave a false name when he ran into the police. He wasn't doing anything wrong. He gave a false name because he had been on the lam from. No comment as to any other charges other than charge 8, problem sexual behavior. He began his parole on March 10th. 19 days later or 18 days later, they searched his phone or look at his phone. There's absolutely no proof in Exhibit N when any of this was accessed. There's no proof when it got into his history. There's no proof. There's no video evidence. There are no illicit photos. There are no illicit images. So I don't know what the accessing sexually explicit plank is. I certainly don't think that there's any proof that he was the one that put this in. We don't know when. We don't know if he was even on parole. So the condition may not have applied. Thank you for your time and consideration.
Thank you.
We also don't know who may have put any information on a phone. Could have been someone that he was lending the phone to. Thank you.
Thank you. So I'm just going to take a moment to go over the findings. Okay, so let's go look at this. So on charge number 1, I do find that you violated the condition of reporting based on the evidence provided in support of the charge. That's Exhibit A and Exhibit D. On charge number 2, I find that you violated the condition of GPS based on evidence provided in support of the charge. Exhibit A, D, E, and G. On charge number 3, I find that you violated the condition of residence based on evidence provided in support of the charge. That's Exhibit A, D, H, I, and J. On charge number 4, I find that you violated the condition of absconder based on the evidence provided in support of the charge. Exhibit A, D, H, I, and J. On charge number 5, I find that you violated the condition of obedience to the law based on your conviction of interfering, which is Connecticut General Statute 53A-167A on September 26, 2024, when you were sentenced to unconditional discharge. And in addition, the following evidence supports the charge, Exhibit A, D, and O. On charge number 6, condition of drugs, I make a no finding as the state failed to provide sufficient evidence to support these allegations based on the information reviewed. The charge states that on March 28, 2022, Mr. Holloway submitted a urine sample for toxicology testing, and the same test provided positive for cocaine. However, state's Exhibit L, the toxicology report, shows a negative result for cocaine. On charge number 7, I find that you violated the condition of halfway house placement based on the evidence provided in support of the charge. That's Exhibit A, D, H, I, and J. And on charge number 8, condition of problem sexual behavior, I make a no finding based on the fact that the Board of Pardons and Paroles implemented revised conditions regarding supervised persons' use and access to the internet and possession and viewing of adult pornography. So per the new conditions, the allegations contained in Charge B as it relates to internet use and adult pornography do not constitute a violation of parole. So accordingly, I'm making no finding as to that specific charge. So that concludes the fact-finding portion of this hearing. Before I make my recommendation, you do have the opportunity to speak to your background and history, and the purpose of this part of the revocation hearing is to help determine what outcome I will recommend.
I just have one initial question. I have a sentence end date is May 10th, 2025. Is that what you have? Yeah, okay. I believe, and I know I saw you read the letter of support, so I just ask that you consider that.
Absolutely.
My client is a single 25-year-old male. He receives his primary support from his girlfriend, his mother, and maternal grandmother. He suffered a significant loss in 2021 when his paternal grandmother passed away. She had full custody of him growing away, and she passed away due to COVID-19. Unfortunately, in 2022, my client's father also passed away. He has one daughter who will turn 3 on January 6th. He would like to see her for her birthday. He graduated from Manchester High School. He was working at Trader Joe's back in 2021, and most recently he was employed washing dishes at a diner. He obtained, while incarcerated, a job in waste management and joined Tier 2 until he transferred to Osborn. He wishes to enroll in trade school and study electrical, and upon reinstatement, he wishes to be placed in a halfway house in Hartford, aside from Watkinson House. He's amenable to all treatment recommendations. My client absconded after a brief period of time. He did not commit any violent crimes. He merely was avoiding being detected by giving a false name and received an unconditional discharge. Almost all of these violations have to do with his leaving. He was gone for some time. I don't think a total revoke is appropriate. I think it would be the easy decision to make, but I would believe what this young man needs before he's out on his own is a period of supervision by parole due to his young age and the fact that he was working while he was out. None of this is violent. I would ask that he be released perhaps in late December so that he can make his daughter's birthday and then have approximately 5 months in parole supervision before he's free. Thank you for your time and consideration.
I do have a question. Mr. Holloway, where were you for 2 years?
I was living with my mom.
So you were just, where's that, Hartford?
No,
Area?
Manchester, Connecticut.
Manchester area? So you were just living with your mom?
Grew up, yeah.
Yeah. And that's when you were working under the table for the 2 years?
Yes, ma'am.
What diner were you working at? Were you working at Vernon Diner? Were you working at Ryan's? What diner were you?
It was the one in East Hartford. It was
Okay, yep.
Yeah.
Okay, so I'm just going to review the evidence, and I just listened to testimony, so just want to put it all together, and then I'll let you know of my recommendation. So I have listened to testimony, and I have reviewed all of the evidence submitted. And based on that, I am going to recommend that your parole be revoked and that you serve an approximate 9.5 month sanction. That's a revoke with a no new parole date, as your special parole term is set to end May 10th, 2025. And in the event the board decides to lessen my recommendation, I'm going to also recommend the following conditions: behavioral management program for domestic violence, no contact with your co-defendants, Joshua Dion and Charles Rivard, no contact with your victim, JD, a general no contact with RM, BR, or SR, and a mental health evaluation. The problem sexual behavior treatment as well. And you mentioned Halfway House, Hartford, just not Watkinson, correct?
Correct.
Got it. All right. My recommendation is going to be forwarded to the board on November 7th, 2024, and then you'll receive a written notice from them following that date. The board may lessen the recommended sanction. They may let my recommended sanction stand, or they may impose a sanction longer than what I recommend. Oh, they can't. They can't. So that's it. So it's either they'll either adopt it or they'll lessen it. Okay. And you will get the notice after that hearing of what they do. Okay. Any questions?
No, ma'am.
So, sir, the board's going to meet on the 7th of November. Call my office or have someone call my office for you, okay? And we'll let you know what the board decided as their final decision, okay?
All right, thank you. I appreciate
You're
it.
welcome. Have a good day, sir.
All right, you too.
Bye-bye.
There's a revocation for Jerris Holloway. Thank you. I'll be right with you. You're Mr. Symes, correct? Yeah? Okay, you're gonna have to answer me with words, okay? Because I can't always see your emotions, okay? I'll be right with you. Okay, good morning. I'm Parole Officer Truscello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Derek Symes, inmate number 300964. Today is Monday, October 28, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborn Correctional Institution. Can you please state your full name and inmate number for the record?
Symes,
And your inmate number, please?
300-964.
This is a public hearing, and public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release, and I will review and make findings of facts to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence. That is, the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence to support the violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will be given to the panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. So today's testimony is going to be taken under oath. So Mr. Symes, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give shall be, concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yeah.
Thank you. We're going to go over the procedure for the hearing. So first, I'm going to read you your rights. Then we will review the parole violation charge that the state, your parole officer, is bringing against you. Then I'll review and identify the exhibits filed for the record. The state is not present at today's proceedings, so you will have an opportunity to present any relevant testimony and any relevant documents towards the charges. After the consideration of all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Yeah. You have rights to this hearing, and I'm going to review them each with you now. You have the right to be represented by an attorney at this hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney can represent you at this hearing? Would you intend to seek counsel for this hearing?
No.
So you wish to move forward as your own representation?
Mm-hmm.
Can you just say yes or no, please?
Yeah.
Thank you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice? You never
No.
received the written notice? No. Would you like a continuance so that we can provide you with the notice and evidence charged against you?
Mhm.
You would. Okay. So just so you're aware, Mr. Symes, that will push your hearing out until November 19th because we need time to get you the packet, okay?
Mm-hmm.
Right. And you still wish to represent yourself, or would you be interested in an attorney?
No, I'm fine.
So no attorney, but you would like a continuance for the
Mhm.
evidence?
Mm-hmm.
Did you move facilities recently? I just want to see, because normally we send it. I mean, did you move facilities recently?
Mm-hmm.
No? I do have that you signed this notice on August 20th, 2024. Does that sound familiar that you met with your parole officer
Mm-hmm.
and signed the notice and received it from them?
No.
That does not sound familiar. You don't believe that happened?
Sure it happened.
Where would you would have been in Hartford County. So you do not believe that is your signature?
Mm-hmm.
Okay. Let me just consult with my supervisor quickly because I just want to make sure that we can continue it for that date, okay? Okay, we're back on the record. Thank you, Mr. Symes. I just wanted to consult with my supervisor so that we can get the evidence to you, okay? So we're going to continue this case, but you do understand that at the continuance date, we're going to move forward with the revocation process, okay?
Yeah.
Okay, so we'll continue this until November 5th, 2024, based on the offender's request to receive his evidence and review his evidence. I am going to ask one more time, since we do have a continuance already. Are you sure you are not interested in an attorney?
Mhm.
Can you use yes or no, please, and speak loudly so you can hear it? No, you do not want an attorney. Okay. All right, so we will continue this case until November 5th, 2024 for Mr. Symes to get his evidence as he requested. All right, you are all set, Mr. Symes. Thank you for talking to me, okay? This concludes the revocation hearing for today, October 28th, 2024, for Derek Symes. Hi, are you Mr. Ward?
Yes, ma'am.
Great, I will be right with you, okay?
Okay.
Good morning. It's still morning. I'm Parole Officer Truscello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Zaire Ward, inmate number 435992. Today is Monday, October 28th, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Zaire Ward, 435992.
This is a public hearing, and public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. And this hearing is being recorded. So the testimony at today's hearing will be taken under oath. So Mr. Ward, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
So what I'm supposed to say, miss?
Either yes or I do.
Oh, I do.
Okay, so you do understand that?
Yes, ma'am.
Perfect. So we're going to go over the procedure for this hearing. You can put your hand down. Thank you. First, I'm going to read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I'm going to review and identify the exhibits filed for the record. The state is not present at today's hearing. However, you will have an opportunity to present any relevant testimony and any relevant documents. After the consideration of all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have the opportunity to speak to your background and your history. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights at this hearing, and I'm going to review them all with you now. You have the right to be represented by an attorney at this hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney could be representing you at this hearing?
I did, but I didn't know. I was getting like letters in the mail, but I didn't know like what that meant. So I didn't like, no.
Okay, do you intend to hire an attorney, or are you looking for appointed counsel?
I don't know what it's gonna be for like right now.
It won't be for today. No, we'd have to continue your case.
Oh, then so no, it's okay.
You're okay with moving forward without representation?
Mm-hmm.
Did you receive the written notice with the charges of the violation against you?
Yes, ma'am.
And you have the right to review the evidence against you before the hearing and right to submit evidence for this hearing. And in addition, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand all of these rights and are you ready to move forward?
Yes, ma'am.
And just again to confirm, you're okay with moving forward today without legal representation?
Yes, ma'am.
So we're going to review the charges that the state, your parole officer, has brought against you and information underlying each charge. On charge number 1, condition of absconder, the charging officer reported that on July 29, 2024, you left the Sierra Center halfway house on a work pass and never returned. You had no further contact with Sierra Center staff or this officer. At this time, you have not returned to your only approved parole residence. Subsequently, your whereabouts in the community are unknown. On charge number 2, condition of halfway house placement, the charging officer reported that on July 29, 2024, you left your only parole approved residence, the Isaiah halfway house, without authorization and did not return. You failed to contact the parole officer halfway house staff and you failed to return to the program. Your whereabouts are unknown at this time, and also your actions violate your signed halfway house agreement, specifically the clause which reads, I will not leave the physical confinements of the halfway house unless authorized by program staff or parole. I will only go to the location located on an approved community pass unless changes have been authorized by staff. The state has filed the following exhibits pre-marked for identification purposes as Exhibit A, the remand to actual custody order, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the notice of parolee rights, Exhibit E, the signed PCS conditions, Exhibit F, the signed halfway house agreement, and Exhibit G, the Sierra House halfway house incident report. In addition, the state filed an addendum to the parole violation report on September 11, 2024, and that is admitted into evidence and reads as followed. In reference to the parole violation report submitted by P.O. Elder regarding Zaire Ward, the following applies. On August 28, 2024, the Board of Parole issued a warrant based on the report declaring the offender an absconder from special parole supervision. On August 30th, 2024, the case was transferred to FIU for investigation. And on September 11, 2024, Word was located by FIU. Word was transported to New Haven Correctional Center where remand to custody order was lodged with AP staff, and Word was served his notice of parole violation and provided his parolee rights. Parole violation notice, parolee rights, and remand were scanned into evidence in case notes on September 11, 2024. Mr. Ward, did you receive this notice of parole violation, the parole violation report, and all the other documents I marked for identification purposes?
Yes, ma'am.
Yeah. I do not have any exhibits, correct? Did you submit any evidence on your own behalf? No defense exhibits.
Oh wait, did I have to like send them back to like the board?
If you had any evidence that you wanted to submit, you could have. But if you don't, are you ready to move forward with this hearing still, or would you like time to submit evidence?
No, I'll move forward.
You're ready to move forward? Okay. So this is now your opportunity to speak to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. And at this time, you may question any of the evidence or testify regarding your case. Do you have anything to say regarding the charges against you?
Yeah, well, I was in the halfway house from January all the way till the day the incident happened. And my PO had called me the day it happened. He told me I had a charge. I also told the PO, a PO that called me to tell me like to turn myself in. He told me that I had a assault charge. So I was at work when he called me and said that, and I just didn't come back. I was scared, so I just didn't go back. And she had called and told me that what was going on. I had brought it to her attention that what he said. She said that I didn't have no other charges, but the charge I have for not coming back. So she just told me to turn myself in, and I was like, okay, and I turned myself in. But
sorry, keep going.
From January to the incident, I was actually doing good. I was actually doing good. I had jobs. I never had to write up in the halfway house. I was actually really doing good. And that incident happened, I just didn't. I told her that I was scared to go back because he said I had a charge that I obviously didn't have because she said I didn't have it. So she just told me to turn myself in and I'll be okay. So I just turned myself in.
Okay, so just to clarify, you left that halfway house that day because you were informed by your officer that you'd have a pending charge coming?
Yes, ma'am.
In July, and then now in September, you called back and you ask about it, and they're saying that that pending charge is no longer there.
Yeah, I never had a charge.
Can you confirm for me or clarify for me, is it the Sierra house Sierra Center, or is it Isaiah?
I don't know what Isaiah, I was only in one halfway house and it was Sierra house. I never was in no other halfway house.
So you were never in Isaiah house?
No, I don't know what that is.
Okay, but you were at the Sierra house, correct?
Yes,
and
ma'am.
that is that's the halfway house that you absconded from, correct?
Yes, ma'am. And the PO name is Elder. That's the Parole halfway house.
That's who you were reporting to, PO Elder?
Yes, ma'am.
And I am gonna make you repeat yourself one more time. I just want to make sure I have everything. So it's July, you contact your PO, they tell you have an assault charge pending.
Yes, ma'am.
Made that decision then to leave and not go back.
Yes, ma'am. I was at work when it happened and
You're gonna avoid it. Okay. Come September, you're saying you reached out to your parole officer? What happened?
No. She called. I didn't have a phone. She called my mom and my mom called me on FaceTime and told me my mom told her what happened and how I was scared that I had an extra charge and a PO, I don't know her name, or her name Emily. She told me that I didn't have no extra charges. I only have absconder. So I was like, okay, I feel better now. Now I would turn myself in.
Okay.
And I did so.
That's what happened. Okay. So you were approximately unaccounted for about a month in the community?
Yes, ma'am.
Sure. So I'm just going to take a moment. I just want to review the charges and then I'll let you know my findings, okay?
Okay.
So, okay, so on charge number one, I do find that you violated the condition of absconder based on the evidence provided in support of the charge. That's Exhibit B, Exhibit E, Exhibit G. That's all, the 3 exhibits. On charge number 2, I make a no finding on the condition of halfway house placement because I feel as the state did not provide the exhibits needed as you testify that you were not a resident at the Isaiah house. Therefore, I do not believe that the elements were met for you to violate this condition of halfway house placement, okay? So I do find findings for absconder, but I have found no findings for halfway house placement.
Okay.
All right, so this concludes the fact-finding portion of the hearing. Before I make my recommendations, you will have the opportunity to speak to your background and any future plans that may be in the works for you for your reinstatement, okay? You wish to make a statement?
So you basically telling me like to tell you like what I'm gonna do when I get home?
Well, you can say anything you want to say. So any plans for reinstatement or things you did in the community? You mentioned you were doing well already. You had said that prior that you had a job, correct?
Yes, ma'am. I had a job my plan. So when I first got parole, they stipulated me to halfway house, but I didn't want to go to my town. I thought it was going to actually be a bad idea to go to my town. But when I went to my town, it wasn't really hard to stay out of trouble. All I had to do was go to work. So I had got a job the first month of January, or the first month I got to the halfway house all the way till I got arrested. And my plan was really to work until I got up to halfway house and save up. My mom, I got a good support system. To go live with my mom, and she's about to actually move to Florida. So go to Florida with her and basically start over. I want to start driving trucks and CDLs and start doing stuff like that. And she was gonna help me save to get a box truck. So I got a lot of plans. It was just this minor mess up was just messed me up really, because I was actually really doing good. I never got rolling up in the halfway house. I got a good report with the halfway house. Did what they asked. It was just that minor.
Okay, thank you. And all the information you just provided is noted for the record, okay?
Yes, ma'am.
So I'm just gonna take a moment and then I'll let you know what my recommendation is.
Okay.
Mr. Ward, are you aware that your parole ends soon?
Yes, ma'am. And I think January 26th.
I have January 26th also, okay? So I just want to make that noted. So I have listened to your testimony and I've reviewed all the evidence that has been submitted. And based on that, I am going to recommend your parole be revoked and that you serve an approximate 4.5-month confinement as a sanction. So that's a revoke with a no new re-parole date, okay?
All right.
Since your end of sentence is January 26, 2024. So my recommendation is going to go to the board on November 7th of this year, so in a week or so. And if they choose to lessen my sanction, I'm going to recommend that they set the following conditions. That's no contact with your co-defendant, JC, halfway house placement, and mental health evaluation, okay? So again, my recommendation is going to be forwarded to the board November 7th. Shortly after that date, you'll receive a written decision in the mail from them, okay?
Okay.
If they choose to lessen, so what they can do at that hearing is they can lessen my sanction. They can give you less time than your end of sentence. They can let mine, or they can let mine stand. Those are the only two options that are going to happen at that hearing on November 7th, okay?
Okay.
All right, any questions for me right now?
I got one more question. So January the 26th, That's my max out there, right?
Correct, right? You're not on
Okay.
special parole. That's what I have. Discretionary. Are you on
Okay,
discretionary parole right now?
what that mean?
Are you on special parole?
No, I'm on regular parole.
It's regular, right? It's part of your sentence, correct?
Yes, ma'am.
I'll just double check. Oh, I did the wrong thing, sorry. 43592. Yeah, you're on regular parole. So, yes. So we will ask that my recommendation is that you have no new re-parole date. So
Okay.
that once that sentence ends, I'm not familiar if you have probation or anything like
Yeah, I
that
have
after it. You'll have
probation.
probation, you'll have to worry about them at that point, okay?
Okay, so no more parole after that.
Well, no, and there's the event that the board may lessen my decision, so look for the letter in the mail from us after November 7th, and it'll give you the information on the sanction, okay?
Okay.
All right, thank you, Mr. Ward. Have a good day.
You welcome, you too.
Good to hearing for Zaire Ward.
Good luck.
Thank you so much.
You're welcome. Have a good weekend.
You too.